how to avoid the metaphorical second-headed monster, the tax man. Oh my. Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question is, what is the stepped-up basis when it comes to estate planning? Folks, pull up your chair because this is a big subject matter and it's often overlooked. Well, folks, let's explore that. The stepped-up basis, folks, is when an asset appreciates in value during your lifetime and you want to give that asset to your loved ones, okay? Typically in a setting, Bill and Mary create their trust, and that's step one of the process. They say, hey, Bill and Mary create their trust. And they say when they're gone up to their cloud, their three cherubs, their three beloved children, Mo, Larry, and Curly, get everything in equal shares. That's all well and good. And if the trust, folks, and you want to write this down, is considered a grantor trust under the Internal Revenue Code, and it legally complies and qualifies as a grantor trust, then the assets that were put into that trust, whether it's a home or a second home or investment assets and so forth, then Mo, Larry, and Curly should get that stepped up basis. And what is that, folks? It's called stepped up basis or date of death value. Date of death. That's right, folks. Date of death of Bill and Mary. So if Bill and Mary, say, paid $50,000 for their home 40, 50 years ago, and they put it into their trust, okay? They named their three children as the beneficiaries of their trust. Now, the house at the time of their passing is worth $550,000. We want Mo, Larry, and Curly to get the stepped up basis, okay? The date of death value of $550,000. Because now, when Mo, Larry, and Curly go to sell that property for $550,000, they're not going to pay capital gains tax in that hypothetical example. Whereas, if Bill and Mary put their children's names on the house while they were still living, they made what they call a completed gift. And Mo, Larry, and Curly are not going to get the stepped up basis. They're going to get what they call the carryover basis. And what was that again? If you recall, $50,000. That's what Bill and Mary paid for the property. They put Mo, Larry, and Curly's name on the deed when they're still living. Not a good approach, not good planning, because now Mo, Larry, and Curly are going to get the carryover basis. And then when mom and dad pass away, the kids go to sell the house. Their carryover basis is what they take. From a tax standpoint, $50,000. The house is worth $550,000. They sell it for $550,000. They have a $500,000 gain. Do the simple math, folks. $550,000 minus $50,000, $500,000 times the 20% capital gains tax rate, typically 15% federal, 5% here in the Commonwealth of Massachusetts, state-wise, and that's a total of 20. So $500,000 gain times 20% would give a $100,000 capital gains tax bill under that scenario to Mo, Larry, and Curly. Will Mo, Larry, and Curly be happy with their parents? Absolutely not. So folks, you need to know about the stepped up basis, and you want to write this down as well. The Internal Revenue Code that will currently allow the stepped up basis in your trust, a grantor trust, is called Internal Revenue Code 1014. There's some other tax language as well, and some other important language that your state elder law attorney will need to put in there, so your trust will qualify as a grantor trust under Internal Revenue Code 1014. Typically, language expressly needs to be in the four corners of your trust, expressly written in the language, saying this isn't the intention of this trust is to be a grantor trust under Internal Revenue Code 671 through 679, and then you put other language in there as well, called limited power of appointment and so on. But folks, this is not a do-it-yourself project. This is tax planning. You need to get that stepped up basis, but in order for you and your loved ones to get it, the trust has to qualify under the Internal Revenue Code as a grantor trust. Revocable trust should qualify as a grantor trust so long as it has the language in there. Caveat, caution, irrevocable trust typically would not qualify as a grantor trust unless it has the expressed language in there. So folks, this is a rather complicated subject matter with transferring property. Long and short of it, the takeaway, typically the children will get that stepped up basis when they receive the property after you're gone up in your cloud. The big danger, the big detriment is when you put their names on the property when you're still living, because then they're going to take your carryover basis. And then when they go to sell that property someday, they're going to get hit with that big capital gains tax. Folks, hopefully you found this video helpful. Any questions? Scroll down, post a comment, a question, and a member of our team will get back to you as soon as possible. Folks, also make sure you subscribe also to our channel, because we will keep you updated with other important elder law matters. And by all means, pick up a copy of my book on Amazon, Patrick Kelleher, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law. Thanks for joining us here today.